Hello. In this presentation I'd like to talk about the regime of islands in the law of the sea, and in particular I'd like to do so in relation to what's presently the leading case on the issue, the South China Sea Award. And actually the case also raises some questions about how do we interpret some of the complex and ambiguous provisions of the Law of the Sea Convention that we've seen throughout the course. So we can't tackle the question of what the South China Sea Award of the Arbitral Tribunal says about the law of islands under the Law of the Sea Convention without giving some context about the nature of the dispute between the Philippines and China in that case. So let's think about that for a second. So we have a map on the right, and a larger version of the image is available online. It's reproduced from the American Journal of International Law. And what it shows is the line that has appeared on Chinese maps published to the outside world since 1947, which have shown a 9, 10 or 11 dashed line in the South China Sea. In the image you can see that line is represented by orange dashes down here and encloses much of this space. So this light space is the area beyond archipelagic or straight baselines. And if you look at the fuller image, what you can see is there's a dotted line here near this text, which is the 200 nautical mile limit from declared baselines. So it's obvious that the 9-dash line goes deep within waters that the Philippines would ordinarily perhaps consider to be part of its exclusive economic zone. And the line also comes very close to countries such as Vietnam, Brunei and Malaysia. Now we'll go into Chinese arguments about the line in more detail later, but the point is, in terms of the modern law of the sea, the precise legal significance of the 9-dash line has never been clearly and plainly articulated. And there are essentially two possible interpretations of what China has said about the 9-dash line. The first is that the 9-dash line is intended to enclose a massive area of historic waters over which China is either claiming complete sovereignty, a position they do not appear to have taken in relation to the dispute with the Philippines, or alternatively some set of less than sovereign historic rights. And we noted the regime of historic waters in the last video being essentially always a question of proving the long-standing existence of special rules that were acknowledged by the states involved. So there's not one law of historic waters. It's a question of proving the existence of a special legal regime in each case. And then there's a further question of whether that special legal regime has been preserved, modified, or entirely replaced by developments such as the Law of the Sea Convention. We'll come to those points in another class. The other possibility, which is the one that we'll focus on in this presentation, is that effectively the 9-dash line says everything that constitutes a maritime feature, be it an island or a rock, within this line is ours, and we therefore have rights to all of the zones generated by those islands and rocks. And indeed, if every feature in, for example, the Scarborough Shoal and the Spratly Islands and the Reed Bank was found to be an island, in the full sense that we'll come to in a moment, then it might well generate maritime zones going quite close to the Philippines, which would give rise to an issue of But if the Philippines coastline also generates zones, where should the line be drawn? So this brings us to the basic sort of background of the dispute. Now, again, an essential point to make here is that we will come back to the Law of the Sea Convention compulsory dispute settlement procedures in far more detail in a later class. But for the present purposes, we should note that both the Philippines and China are parties to UNCLOS and are, as a starting principle, bound by its compulsory dispute settlement procedures. Now, the Philippines is in concrete terms concerned not just by what the 9-dash line might mean, but also by Chinese island building within 200 nautical miles of its baselines. For example, the Chinese military installation on Mischief Reef, which, as in our title slide, involves dredging sand up from the seabed and depositing it on a reef to form an artificial island. And also, it has been concerned by Filipino fishermen being chased away from various fishing grounds in the South China Seas by Chinese vessels, both government and non-government. So in legal terms, the issue here would appear to turn on delimitation. Where do China's zones end, particularly its exclusive economic zone, if we presume it is in fact sovereign over islands in this area of the ocean? However, the difficulty we face here is that China had opted out of compulsory dispute settlement under Article 298(1) of UNCLOS regarding delimitation disputes. So, in this sense, the Philippines cannot bring a case about where the line in the sea should fall between any Chinese islands, and the case doesn't raise questions directly of who is sovereign over these various features, but between any Chinese islands and the Philippines mainland. So what the Philippines did as a matter of litigation was quite clever. The Philippines' litigation strategy was not to contest sovereignty over the disputed islands and not to ask for a delimitation, but rather to argue that these features in question are not islands at all, and therefore, even if Chinese, they generate no overlapping zones, or at most generate small territorial seas that might be enclosed by a Philippines exclusive economic zone. So the key question for our purposes then becomes, as a matter of the law of the sea, when is a rock an island? So as we've seen, under the UN Convention on the Law of the Sea, an island generates a full suite of zones, most particularly the right to a continental shelf and a 200 nautical mile exclusive economic zone. And that represents substantial potential economic value in terms of access to fisheries and also potentially in terms of access to oil and gas reserves. Now, while it's often been speculated that the South China Sea has massive oil and gas reserves, it would appear that those estimates on present scientific information may have been overly optimistic, and that the principal economic value of the South China Sea is in terms of fisheries. We'll come back in later classes to other questions of security in the South China Sea in terms of its strategic value. Well, no, I will touch on some of those questions a little later. But in any event, one of our key distinctions here is obviously between an island and a rock. So a mere rock will produce only a 12 nautical mile territorial sea, plus a contiguous zone, though why you would want to prevent customs infringements occurring on a rock might be open to question. And a so-called low tide elevation will generate no zones at all, though it might have some impact on baselines, as we've looked at in the previous video. Now, if the essential point here is, as I've already made it, if various features in the South China Sea are not islands, if they're instead classed as rocks or low tide elevations as a matter of law, the scope for overlapping maritime claims is substantially reduced or potentially completely eliminated. And the other point to note for present purposes is that when we're talking about low tide elevations, these were found by the tribunal to not be capable of sovereign appropriation. So, as it were, a state might well be sovereign over an island or even an uninhabited rock that would appear to be in another state's exclusive economic zone, and thus will generate overlapping claims. However, a low tide elevation, a feature that is only above water at low tide, such as the top of a reef, is not capable of sovereign appropriation. It just belongs to the zone in which it is found. So as it were, it's something like a fixture or fitting just attached to that zone, rather than a piece of real estate that can be acquired by a sovereign power. And that becomes important in understanding the award. So this classification of is it an island, is it a rock, or is it a low tide elevation is extremely significant. First, because of the value of the zones generated, and second, because of the extent of overlapping zones that might be generated with another state's claims. And just to make a sort of point about this, this is ROCKALL Island, and you can just see in the image someone standing on top of it. So it rises out of the Atlantic Ocean, and it's about 300 kilometres west of Scotland, and some 700 kilometres from Iceland and nearly 600 kilometres from the Faroe Islands. Now, for a long time, the UK maintained that ROCKALL Island was not, as its name suggests, a rock, but an island. And this had the effect of pushing out the UK's fishing zones by some, 300 or 400 kilometres, which potentially made a big dent into the fishing zones of the Faroes or Iceland. And after long negotiations between the various parties, the UK changed its position and now acknowledges, perhaps rather more fairly, that ROCKALL Island is in fact simply a rock and generates only a 12 nautical mile territorial sea. So the UK is capable of being sovereign over this patch of ground, though it's mostly vertical, because it is always above water, even at high tide. But this is one of the kind of classic disputes about, is it a rock or is it an island? So if we then turn to the South China Seas, and I'll get the last image up in a moment, but here we see one of the features under dispute, Fiery Cross Reef. So in the top right of the screen, we can see the reef in its state before it was reclaimed, and here in the bottom left, we see what it looks like after a substantial quantity of sand has been put on top of it. You can see perhaps here this may be a dredging vessel because of the pipes in the water. But obviously it's been substantially extended. It now has many buildings. It will be consistently above water at high tide in a way that the reef wouldn't have been, except perhaps for very small areas. And now has a very long military aircraft landing strip. And that's the state it's been in, obviously, since at least July 2015. Now, the significance of having an air landing strip strategically in this part of the world can be seen here. So if you look at this radial image, if you have a landing strip on Fiery Cross and Mischief Reef, where aircraft could potentially refuel, or from which they could take off or land, then within 1,000 kilometres you cover most of the Philippines, Vietnam and Cambodia. It's potentially an important forward base from a military point of view. The other thing to consider briefly, but we may come back to this in more detail, is that strategically, from China's point of view, as a military power with an increasing naval presence, it is geographically encircled by other states. And in the event of a global naval conflict, it would, as it were, have to punch out through potentially hostile states surrounding it to the open ocean to be able to operate effectively. So pushing its defensive perimeter out is strategically attractive, and also historically China suffered what's often referred to as the century of humiliation from the time of gunboat diplomacy and the Opium Wars in the 19th century through into the 20th. And these threats to China always originated from the sea. So securing its coastline and securing a forward perimeter is not an irrational strategic concern, whatever the merits of the legal case. All right, so we need to come back now to the legal definition of islands under the Law of the Sea Convention. And we've examined before in class Article 121. So it's worth, though, going over the wording again in full. Paragraph 1, an island is a naturally formed area of land surrounded by water, which is above water at high tide. So ROCKALL Island would, superficially one might think, satisfy that definition. Now, and paragraph 2 is why islands are valuable, except as provided for in paragraph 3. The territorial sea, contiguous zone, the exclusive economic zone, and the continental shelf of an island are determined in accordance with the provisions of the Convention applicable to other land territory. So an island can massively extend your maritime claims. However, the critical words are, of course, in paragraph 3, rocks which cannot sustain human habitation or economic life of their own shall have no exclusive economic zone or continental shelf. So the question we really have to ask is, what is meant by these phrases, human habitation or economic life? And this was a live issue in the South China Sea dispute. So how do we interpret it? Well, the approach taken by the arbitral tribunal in the South China Sea Award focused on, obviously, these words. Rocks which cannot sustain human habitation or economic life of their own. So, first, we have to attempt to define sustain human habitation, economic life of their own, and whether there's any link between those two concepts or whether they are completely separate, as perhaps indicated by the word or. So this is a question of the plain textual meaning of Article 121, paragraph 3. But then the arbitral tribunal asks, who was intended to benefit from the creation of the exclusive economic zone? Which states and which peoples? So that's a question going to the object and purpose. And finally, the question arises, what approach should we take to the negotiating history of the Convention? How should we use that negotiating history in interpreting Article 121.3? So that's a question about the role of supplementary means of interpretation. Now, you'll remember that the basic rule of treaty interpretation under the Vienna Convention on the Law of Treaties is that provisions are to be given their plain textual meaning, that the ordinary meaning of words is to be used, but in light of their object and purpose, and that under certain circumstances, particularly where there is ambiguity or to confirm the ordinary meaning, we can look to supplementary means of interpretation to do that job. So all of these techniques are mandated by the Vienna Convention on the Law of Treaties. So this is a perfectly ordinary way to attempt to go about the job of treaty interpretation, at least on its face. So the question then is, what did the tribunal do with these interpretive principles? So the first point that's raised is, in the final award, is this one. The fact that a feature is currently not inhabited does not prove that it is uninhabitable. The fact that it has no economic life does not prove that it cannot sustain one. Historical evidence of human habitation and economic life may be relevant for establishing a feature's capacity. So step one, we're going to look at how the maritime feature has been used in the past. And the tribunal does put some weight on historic evidence of continuous human habitation over a period, even if a feature is no longer inhabited, because, as they note, human beings have shown a remarkable ability to live anywhere that is capable of habitation. So if a feature has never been inhabited, that's pretty good starting evidence for the idea that it's not inhabitable. In any event, they then come to the question of or. So in lawyerish language, human habitation or economic life is plainly disjunctive. It's one or the other. One would think these are two separate tests. The tribunal notes, however, that the two concepts are to some extent linked. Now, the tribunal notes, and this is an important idea which is developed further later, that the drafting on its plain meaning covers islands which may sustain human habitation but not economic activity, or vice versa. And it's the vice versa that becomes important. Economic activity but not habitation. And that this may be particularly the case where multiple islands are used in concert to sustain a traditional way of life. So they raise this idea that you might have a human population that lives perhaps only on one island, but uses the resources of a number of adjacent islands in sustaining a traditional way of life based on perhaps sustainable fishing of the shallow waters surrounding those other islands. Okay, so what is an economic life of its own? So the tribunal says that Article 121.3 requires a link between the economic life and the feature itself, rather than it merely occurring in the adjacent waters. So the logic here is that you can't say, well, if this feature had a territorial sea, that territorial sea would be valuable, therefore it has an economic life of its own because we could do things like fishing there or exploiting seabed resources. That's putting the cart before the horse. You have the zone because it's an island, not something is given the status of an island because if it were, it would generate valuable economic activity. So you have to go back to this idea of a link between the activity and the feature itself. So thus the tribunal says in paragraph 503, economic activity in the territorial sea could form part of the economic life of a feature if linked to the feature itself, whether through a local population or otherwise. Distant fishermen exploiting the territorial sea surrounding a small rock, however, would not suffice. So now we've had this one category set up of people living a traditional life, and now we have this idea of a group of people who aren't a population, who aren't living locally. They are distant fishermen who have come merely to extract resources from the sea surrounding a small rock. And we'll see how that logic plays out later. So the tribunal finds at about this stage that it's exhausted what it can do with the ordinary meaning of the words, and will now go on to consider the object and purpose of the exclusive economic zone. So, the Law of the Sea Convention preamble talks about the convention contributing to the realization of just and equitable international economic order, which takes into account the interests and needs of mankind as a whole, and in particular, the special interests and needs of developing countries. Now, one of the things you can take into account as part of the context of any treaty is its preamble, and the preamble will give you some insight into the object and purpose of the treaty, or its ostensible object and purpose. But a key thing to recognise here is that this particular language echoes the ideas of the new international economic order of the 1970s. So we've spoken in other classes about the role of decolonisation in the law of the sea. So between the 1950s and the 1970s, the number of states in the world leaps rapidly from less than 50 to more than 150. And that involves a number of newly independent states, many with post-colonial histories, who are keenly aware that development and economic wealth in the world is unevenly distributed, and see the existing international order as a significant part of the problem. So the idea of the new international economic order was that surely now a majority of states in the world a majority of developing states should be able to reshape international law to contribute to more just and equal development. Now, as we've seen in our sessions on the history of the law of the sea, that vision was not entirely realised, because in terms of issues like seabed mining, it's very hard to do the seabed mining without the participation of states that have the technology. So you can draft whatever law of the sea you like on the basis of a pure majority, but if you don't have buy-in from the industrial states, then you're not going to be able to carry out those activities, which puts the industrial states in something, the highly industrialized states, in something of a veto position. So a lot of the ideas of the new international economic order did not succeed, perhaps, in fundamentally reshaping international law in the way intended. Nonetheless, this was an important set of ideas present at the time of negotiating the Law of the Sea Convention. So, how do we place the Law of the Sea Convention then in a broader context? So the tribunal then looks at the growth of the exclusive economic zone as an idea. And as we've seen, it was something that crystallized into customary international law, perhaps first through discussions in Law of the Sea Convention negotiations and before the treaty itself came into force. But it has longer roots than that as well. So they look to the state practice, particularly in Latin America, that there was the 1952 Santiago Declaration and the 1970 Montevideo and Lima declarations, all of which dealt with jurisdiction over offshore resources in substantial zones. Further, there was significant African practice in the 1970s, including resolutions of the African States Regional Seminar on the Law of the Sea and the 1973 Addis Ababa Declaration of the Organization of African Unity, all of which backed the idea of ideas similar to what would become an exclusive economic zone regarding the rights that coastal states should have to benefit from the resources adjacent their shores. So all of these instruments exhibit a common concern that coastal populations should benefit from maritime resources of adjacent waters. Now, how does the tribunal in the South China Sea Award then interpret UNCLOS in light of its history? So a fundamental conclusion that the tribunal reaches in paragraph 515 is that Article 121 serves to disable tiny features from unfairly and inequitably generating enormous entitlements to maritime space that would serve not to benefit the local population, but to award a windfall to the potentially different state that has maintained a claim to such a feature. So this is very significant language. There is a distinction that is being drawn here between benefits to coastal populations arising out of their adjacent waters and windfalls to distant states. And remember that earlier reference to distant water fishermen. And they lay out further principles about what might count as an island and what not in paragraphs 539 to 551, and you should probably go and examine those. But the tribunal's conclusions essentially come down to this in paragraph 520. The human habitation with which the drafters of Article 121.3 were concerned was the habitation by a portion of the population for whose benefit the exclusive economic zone was being introduced. Habitation refers to a settled group or community for whom the feature is a home. And there are other references to the word home in the award. So the tribunal is situating its analysis within a history of the development of the law of the sea, where the point of the exclusive economic zone was to benefit particular peoples in coastal states and not to generate enormous windfalls to, though they don't use the word, essentially colonial states which had maintained claims over maritime features, possibly at a great distance from their mainland. However, this only carries us so far because we're talking about human habitation. What about economic life? Could that be an alternative? Well, the tribunal shuts this down, really. It says, as a practical matter, the tribunal considers that a maritime feature will ordinarily only possess an economic life of its own if it is also inhabited by a stable human community. So while leaving the door open to situations where where an island might have an economic life because it's integrated into a set of islands that support a traditional lifestyle, other broader uses of the term economic life seem foreclosed. Other than that traditional lifestyle exception, it looks as though the tribunal has pretty much collapsed the economic life and human habitation tests, or at least very significantly narrowed the scope of an economic life test. So what are the implications here? Well, they're potentially significant for numerous countries, including Australia. So one government that was concerned about the award was that of Taiwan, and let's recall that the government in Taiwan regards itself as the government of all of a unified China, in the same way that the government of mainland China regards itself as the government of a unified China, including Taiwan. So customarily we don't refer to Taiwan as a state per se. Nonetheless, its essential concern was that it has been using Ituaba as a military installation for quite some time. And on its face, it's a substantial island. It's over 1 kilometre long and several hundred metres wide. That said, Taiwan has never proclaimed exclusive economic zones surrounding Ituaba. Nonetheless, the tribunal spent quite a lot of time examining Ituaba, because clearly this is sort of the test case. You know, if Ituaba is found not to be an island, then nothing else in the relevant area that's often much smaller will be. And Ituaba had some evidence of fresh water, although increasingly brackish, and there were substantial historical documents adduced, particularly from archives of maritime explorers held in Paris and London, that Ituaba had from time to time had temporary populations, even an attempt at founding a banana plantation, but these populations never seemed to take hold. They were never sustained for particularly long periods, and certainly no one ever permanently settled there. And the tribunal took this as evidence, in effect, that if several efforts were made at settling the island and none of them took, then that's pretty good evidence that Ituaba was not inhabitable and therefore not an island. This also raises implications for Australia in respect of the Heard and McDonald Islands. So these are enormously remote, thousands of kilometres from Tasmania, deep in the Southern Ocean and quite close to the Antarctic continent. As you can see, they are relatively barren, to some extent covered in moss, and do not have a permanent human habitation. Nonetheless, Australia has proclaimed exclusive economic zones around these islands, and French islands nearby, such as the Crozet Islands, are in a similar position. And those zones are significant. So, for example, in class I've referred to the Volga case, in which Australia commenced a hot pursuit against a Russian-flagged vessel suspected of illegal toothfish poaching in the Southern Ocean. And the reason it could do so, as a matter of Australian law at least, and international law, was its claim to an exclusive economic zone. Now, even at the time of the Volga case, and you'll recall I told you in class, the actual issue of the legality of that hot pursuit wasn't settled in the proceedings. But even in the Volga case, the Russian judge of the Law of the Sea Tribunal, Judge Vukas, raised the question whether the Herden-McDonald Islands should really generate exclusive economic zones, whether they actually pass the test in Article 121.3 of UNCLOS. So certainly Australia's ability to conduct law enforcement exercises and to act, one might think, to some extent in the common interest in preventing toothfish poaching in the Southern Ocean would be substantially reduced if this was held not to be an island. And many other states are in a similar position. There are any number of US maritime features that are claimed as islands, which, if the ruling is applied, would not generate substantial zones. So if you have any questions in relation to this material, I look forward to addressing them in class. But one thing we should obviously bear in mind as a core question is, will the approach by the arbitral tribunal be adopted? A number of members of the Law of the Sea Tribunal sat on that arbitration as arbitrators, so one might expect that the decision will be given substantial weight, but there will be a question as to whether it's followed in other later cases and whether states in general accept it, particularly given that it would result in extinguishing many exclusive economic zone claims. Thank you for your attention, and I look forward to talking about this more in class.